Hi guys, we're going to get started here in just about 2 minutes or so. We're going to let people trickle in and then we'll get rolling. All right, we already got the chat hustling. Got some folks from Dallas, Texas, Albuquerque, New Mexico, lovely humid Florida, Nashville, Anchorage, nice, Philadelphia, Fairfax, Chicago, Seattle, Atlanta. Oh, we got Toronto, Seattle, Chicago Burbs, Jersey, Raleigh. Got everyone from all over. Great to see so many familiar names too. For those of you guys that are just joining, we're going to get started in about 2 or less than 2 minutes, about 1 minute. Kentucky, Florida, Honolulu. Switzerland.
Oh, wow.
Global audience. Cape Cod. Love Cape Cod. Ontario. Hey, Heather. All right. Why don't we get rolling? I know everybody's time is valuable. We are 2 minutes past the 30-minute mark, so let's get rolling. Can everyone see my screen? Yep, cool. All right, guys, welcome to our next Legalese with the Ladies webinar. I'm Sean. For those of you who might not be familiar, I'm one of the co-founders, CEO of Hopskip. Hopskip is a platform that meeting and event professionals use to streamline how they source and contract hotels for business events. I'll let Kelly and Barbara, my two co-hosts, introduce themselves. Barbara, you want to start?
Good day, everyone. Hi, I'm Barbara Dunn. I'm the owner of my own law firm, Barbara Dunn Law, based in the Chicago area and exclusively representing groups in connection with meetings and hotel contracts. And I'm delighted to be here with my good friend, Kelly Bagnall.
Thank you, Barbara. Kelly Bagnall. I'm a partner with Holland & Knight. I am physically located in Dallas, Texas. Although my practice is everywhere, I represent hotel owners, management companies, and brands in relation to all things operational, which include group events. And I'm thrilled to be here today as well.
Awesome. And before we jump into the agenda, we always like to make sure everybody is aware today's presentation is not legal advice. We are here to provide insights, guidance, kind of on what we're seeing, what we're hearing in today's market. But please always, work with your attorney. This is not legal advice. Today's agenda is really going to be what you guys as the audience or the registrants have vocalized to us that's top of mind. So we're going to go through a series of Q&A. Thank you for everyone who submitted questions in advance. We have some poll questions too that we're going to administer throughout the presentation to collect kind of a temperature on certain trends or issues that we're seeing in the market. So please, as the polls come out, answer those timely. And thank you again for everyone who submitted questions in advance. If you do have questions during the webinar, just throw them in the chat and we'll do our best to either answer them live or for the next webinar, we'll make sure that they're included. We're going to start with a poll. And the question we have for the audience is, how confident are you in your understanding of event contracts in general? If you guys don't mind providing your responses to that question now, it looks like most folks so far have said very confident. Now somewhat confident is starting to take the lead. All right, so good thing is we're seeing 0 responses to no confident, not confident at all. And it looks like Somewhat Confident is going to smidge out to be the winner here. Awesome. All right, let's jump to the next slide. Did I lose the slide deck? It's a slide.
Yes, it disappeared.
All right. I don't know why. Give me a sec here. Back. All right. First question. And Barbara, I'm going to actually throw this one to you to start. What are some common pitfalls that are often overlooked in hotel contracts? And what do you think is the best way to mitigate that proactively?
John, I would say that a common pitfall on behalf of the group side, just the basics, getting all of the terminology straight, using consistent terms throughout the contract, watching out for inconsistent provisions, looking closely, carefully at your dates, at your block, at your patterns, at the cancellation fee clause. I've had a number of situations. I just had a call earlier today where within a cancellation fee sliding scale schedule, the date column, the number of days and the specific dates did not agree with one another. Similarly, the percentage of cancellation fee versus a dollar amount didn't agree with one another. Most times you might think this is not a problem, not a big deal, but it is a big deal. So the sooner you can just stop and get in the basics, the better. Slow down as well. I think moving too fast, too quickly for groups in the negotiation phase can just cause a rush. You definitely want to have at least one other person take a look at your contract, if nothing else, just for proofreading purpose, but there are things that different folks will catch. So I would definitely recommend that as well. Use a checklist. We'll talk about clauses and so forth, but using a checklist, especially those of you who might be with a large organization, can be very helpful, especially if you've got lots of different folks within your organization negotiating the contracts. Always address your contingencies. You might have business contingencies. For example, your organization may rely on federal funding to host its meeting, but you also have other contingencies that perhaps other groups deal with, such as a force majeure circumstance, such as construction. We'll talk about those things. But one pitfall is not addressing contingencies because, of course, we know at Murphy's Law, things will come up. Finally, I'll say don't put yourself on the clock. In today's contracts, you're going to see a lot of clauses that specifically refer to you have to respond within 30 days or you have to note disputed charges within 14 days and so forth. While it may be okay in some instances to agree to a time frame, in a lot of cases, those clauses will go on to say that if you miss that time frame, if you, for example, don't dispute a charge within that time frame, you waive or give up an important right to do so. So just be very careful. Whenever you see a time frame, ask yourself from the group's perspective internally, can we live with this from a business standpoint? I think all of that is important. Kelly, as I work with clients and administering the contracts, I'll talk to them about, marking down key dates and so forth. But I know from the hotel's perspective, you've got a lot of folks as well. Once a contract is signed, I know managing contracts too.
Right. And the only thing I would add, and obviously those items that Barbara's mentioned are key for the group side in particular, but I challenge everyone to ask a question. So representing multiple different management companies and different brands, I can tell you that not everyone uses the same terminology exactly the same. And so if you have a question, ask. For example, if an administrative fee, which you will see in a lot of contracts now is included, and you don't know what that is, where it goes, or whether or not it's taxable, even though I do think the contracts spell that out in many ways, make sure to ask that question because that way you'll know what is going to be included in your cost and expenses.
Excellent. And Maurice, I see, asked a question around checklists. So Maurice, we definitely have a lot of resources on the Hopskip website. maybe someone from the Hopskip team can share the URL of our website. You should be able to find a checklist there, but we will also include in the recording that we send out to all registrants any resources that are applicable to that too. So great question. If anybody else has any checklists for Maurice, please feel free to share them in the chat. All right, let's keep going to the next question. Kelly, what does it mean to be named or to name an entity as an additional insured or co-insured on an insurance policy? And what are the risks and benefits to each party?
Well, I thought this was a great question because a lot of people don't understand insurance, and sometimes you don't have a person in a risk department on hand that can help you navigate those types of issues. When you do have access to a risk person, someone who handles the insurance for your company, they are a great resource for you. But generally speaking, to answer this question, there are many times where a hotel, for example, will ask to be named an additional insured on a policy. And what that means is the hotel has the ability, once they're named on your policy, to file a claim directly with the insurance carrier if it arises and is covered by that policy. So you, as the policy holder, would be adding in that context the hotel people, entities, as an additional insured. Now, you will sometimes, we get a request from groups that they be added to a hotel policy as an additional insured. And let me just share with you why that's typically not possible or extremely challenging. With the number of groups that are at the hotel every day, if we were to monitor and have to manage adding those entities as additional insured to hotel policies, we would have to literally have a department of people to do that, because that would be very, especially because a lot of big brands have hotels insured under common policies. And so that becomes unwieldy and unworkable. But basically, the right to stand as an insured under the policy means that if something happens, we could file a claim. If you're not named as an additional insured, that doesn't mean you don't have the right to make a claim under a policy. You just do it in a different way. So those are the risks and the benefits depending on what situation, what seat you're sitting in.
Barbara,
Kelly, and it's a great explanation. Thank you, Kelly. And from the group's perspective, I'll say that insurance is one of the tools in your risk management toolbox. We'll talk about another I word coming up, indemnification. But insurance is a tool. It's a tool for groups to manage risks. So in any circumstance, use common sense. What is the risk level posed by the activity, the goods or the service? And so from the group's perspective, when it's contracting with hotel, what is the risk on the group that the hotel will mess up and get sued and will want to stand, as Kelly described, that's great, as an insured under that policy? Are we hiring a transportation company to move our attendees around? That's a risky proposition. Are we hiring a harpist to play at the cocktail hour? Think about each of the risks, because what the group is trying to do, the group is trying to supplement its own insurance coverage. And Kelly made a great point. In a lot of organizations, you may or may not have someone who's in charge of your risk management, in charge of those policies. If you do, or if you don't, definitely take it upon yourself to gather up what you understand your organization's insurance coverage to be, liability insurance and so forth. So you understand day one what your coverage is. And then when you contract with a vendor, look to see, again, based on that activity, should we supplement our insurance? So again, transportation is a good strategy. Likely the bus company has a significantly high liability insurance policy, perhaps higher than what the group can get. So being covered under that the shuttle company or the transportation company's policy is very important to the group. Again, risk management strategy wise. So I think that the 2 points I would say here, Sean, is just making sure you understand your insurance coverage and you understand the circumstance primarily based on risk management of when you would make that request to be named as additional insured.
It makes sense. Thank you both. Let's go to the next question. what are some strategies for creating a mutually beneficial contract, both buying and hotel property specific? So, Barbara, why don't you lead this one?
I appreciate the focus of this question on strategies. And, I think the concept of mutually beneficial often goes by the wayside when we get into a battle of forms, our clause, your clause, and so forth. So I encourage my group clients to, rather than battle about clauses, pause for a moment and focus on the issues. What issue do you want addressed in the contract, or do you need to be addressed in the contract? And what elements do you want? So for example, we'll talk about construction, and we have our clause, their clause. Look, I just want some basic things covered. I want to know about construction. I want to know what you're going to do about it. I want to have the right to have a dialogue and so forth. For the groups, and especially the reference earlier to the checklist, it becomes important because it focuses on the issues. Do you want the right to reduce your room block, right? What are the issues? You can write the language a whole bunch of different ways. So I'd say come to the table first, your strategy from the group's perspective. Come to the table with the issues that you want to address and the manner in which you want to address them. Second, address the contingencies. Some contingencies might be applicable in all circumstance. I mentioned the construction, for example. Other contingencies might be applicable to just a group circumstance. For example, the people coming to the conference are state officials, right? There may be some government circumstance, so communicate that. It isn't so much the clause as it is the issue, I'll say that. And then stepping back, I understand from the group's perspective, and those of you participating today, we know it's important to walk the walk, talk, understand the other party's issues of concern. So as a group, I understand, hotel, that in order for you to give me rooms and space, you're going to have to have me commit to a certain minimum pickup for rooms and food and beverage, etc. So how can we do this in a way that's going to work for both sides? That's the way the conversation should happen. That's really what I would describe the negotiation. It's a conversation. And at every juncture, hearing the other party's concerns about your issue, in hearing back from them, that's your clue to know where you gravitate for the clause, and offering compromise language that could bridge that gap. It's a very effective strategy. And Kelly, I know from the hotel's perspective, hotels are very good at trying to get to the yes in these clauses. So at least from the group's perspective, those are some of the things that I would recommend from a strategy standpoint. How about you?
So the only thing I would supplement, and Barbara's directly on point on the issues of creating, it's not about the words on the page. It's about communicating the concept that we're both agreeing upon. So I'm not married to any particular language when it comes to a negotiation. I can pivot as long as it's getting across the message. What I would encourage each of you on the group side to do is you must communicate your issues, your message at the time of the RFP. If the hotel is just hearing about your issues and your particular concerns, once you've accepted that hotel and you're trying to negotiate the paper, that's really too late. We need to understand what your issues are so that we can go into the quotes, the analysis, and the communications in a consistent way to address everything for both parties.
And Therese brings up a great point too in the chat. If each side is willing to share what's most important to them, getting to a yes will happen faster.
So let me start with that, Barbara, and then I'll kick it back to you. So most of you have seen what hotel standard forms look like, and because of your experience, which was clearly evident, you know what hotels have already voiced is important to them because they've already put it in their forms. It doesn't mean that they're not willing to negotiate to a different position, but that is what's important to them, is the types of issues that are already expressed in their forms. Now, getting to a yes beyond that, based on your unique issues, that does take a communication factor. Barbara?
Absolutely. I agree with you, Kelly, and I like the strategy of putting it out in the RFP, the request for proposal process. I'd say from the group's perspective, don't hide behind the bad side too, right? Every piece of business has a good side and has a bad side, or what you might perceive to be good or bad. Don't hide behind it. Put it out there. There will be hotels that will still want your business, but I would rather have the group do that day one than not share something that's very important, as you point out, Kelly, day 61 in the negotiation. So put it out there, and look, putting it in the RFP in that way allows the group to give bad news, if you will, context, right? Context of this is why this year pickup didn't look good and so forth. So I think that to me is another great strategy, as is the focus again on the issues, as is the move away from the language and try to just make sure, again, from a checklist perspective, you have those issues addressed and come with compromise language. Listen to the other side. Sean, I think that often becomes an important thing, as you know, with in the means industry, working on both sides.
Exactly.
Listening is really the key, because the folks that can listen and interpret back, I feel like are very effective negotiators.
100%. And the Hopskip users that are on this webinar already know this, but like in Hopskip, since we facilitate the RFP process, one of the items within the RFP on Hopskip is the ability to communicate contract language that you're requesting to have in the agreement with the hotel. So having that information up front and then also getting the hotel's feedback up front is going to save you a lot of time as you progress through the sourcing process. Great points, both of you. Let's go to the next question. Many hotels place a hold on a guest credit card at the time of check-in for any incidental charges that guests may incur during their stay. Kelly, is the hotel required to disclose this requirement in the group sales agreement? Can the group negotiate to eliminate or to reduce those holds?
So let me back into the disclosure of those types of fees on the credit card is already posted on the site, the hotel's website, as far as what the requirements are going to be if you check in as a guest at that hotel. So while we do have groups from time to time request that either the hold not be placed on the guest credit card, or that some lesser amount be placed on the guest credit card, that does create issues. And so technically, when you've got a guest checking in, and if you have a desire that that person would not be have a hold placed on their credit card, that is going to be contrary to the hotel's processes and procedures, which causes issues, because we can't just flip a switch and all of a sudden treat one guest different from another. When those instances do come up where a hotel is willing to place a certain hold and not turn on any any ability for a guest to have any ancillary service, whether that's excess or extreme Wi-Fi, whether it's movies, whether that's room service, whatever that might be, then that is something that creates issue with the guest, because the guests typically have an expectation that they will have access to charge those things to their room. The other piece is that if we were to lower, so the amount of money that's placed on a hold is typically based on a hotel analysis that they've done on the average, typically, of what each guest will consume as far as incidental charges. And so if your group wants to craft something less than that, the hotel is not structured to monitor your individual guests to see if they're exceeding that amount. So in my opinion and in my history, it's either been all or nothing. And if it's nothing, that does create group stress and angst. The way we've been able to resolve it with some groups is that the group takes responsibility that if there is not funds paid to resolve something that a guest might inadvertently charge to their room and gets around them, then the group is responsible for taking the collection end of that, i.e. they pay the hotel and then they go after the individual guests, typically because that person has been there for training or something of that nature. The only other thing I'll say on this particular point, because I know this is probably an answer not many of you like, is that one of the things that you should do with your attendees is confirm with them that they're using a credit card and not a debit card. Because as you know, that hold placed on a debit card could have much more significant effect than on a credit card. Barbara?
Absolutely. Kelly, thanks so much for sharing kind of that background from the hotel's perspective. And I would say from the group's perspective, I have had clients where attendees at a particular conference, the group may feel that there's a disparate impact and that those folks may not have a credit card. Perhaps they do just have a debit card. And so I know a lot of groups up front will put that as a request, again, in the RFP, whether they want a waiver of that or whether they want a reduction of that. And again, the more information they could come armed with, as you mentioned, average spend, that's very helpful too. The other thing I would say is, for those groups that want to make sure certain folks don't have to be encountered, they can put those incidental charges as well, as on the rooming list or for the master account, so that the group would take care of those. Again, not ideal from the group's perspective, but at least as it relates to the guest, we can take care of it that way. And to the point Kelly mentioned at the end about the group being responsible for those incidental charges, many of you will see language in the hotel contract about that. And that language might live in the reservations section under deposits, under individual deposits or cancellation. So just be very careful. Again, take responsibility, eyes wide open. The group has to manage it. But instead, and I like the strategy Kelly suggested, the communication to the attendees is important so that attendees don't have that unpleasant surprise at the time of check-in, or that they understand the parameters ahead of time. And if they do have concerns, certainly the group should create an environment where the individual should be able to come back to the group and raise any concerns they have. Sean, I know these holds could become very important for the hotels and for their groups, and certainly perhaps more so at the resort level than a typical perhaps overflow hotel, but still important nonetheless.
Super important. We're going to actually, before we get to the next question, do another poll here. We want to take a pulse check from the audience on, in today's market, which legal area do you or are you finding yourself struggling with most? And if the poll should be out on your screen, looks like contracts in general is the winner right now. Liability at number 2, labor and staffing now at number 2, and insurance and insurance is the 3rd, and accessibility is number 5. Looks like the breadwinner is just contracts in general, with liability being number 2. Okay, great. Thank you for everyone who answered that poll question. We're going to keep it moving. The next question. Contracts often seem to have many clauses, which we all know, which say the same thing, such as indemnity or force majeure. Is that a concern? What is the best approach to manage this? Barbara, you want to hit this one?
Yes, absolutely. So is that a concern? Those of you playing your bingo cards today, you're going to hear my "it depends." So if you can fill in that spot, or we'll have a bingo card the next time. It very much depends on whether the clauses presumably say the same thing or say different things, because inconsistent clauses just lead to a dispute. And what we want to try to do, what the groups want to do on the front end, hotels certainly too, try to resolve any inconsistent language. So what's the best approach to would manage? First, go back to what we talked about. Identify the issues. Use a checklist first. When it comes to the actual language, the clauses, and writing it up, use small, manageable bites. In other words, the clause addresses one issue, one thing, and it doesn't have a lot of things rolled in. So pulling apart issue-specific clauses is one good strategy to identify whether you do have, in fact, overlap and whether there is inconsistent language. And again, I think part of this happens because it's my language, your language, we got to have this together. That's how a lot of that happens. So whether it's the hotel or the group, unpeeling, pulling back what's in the clause, unbundling the clause, and really focusing on the singular issues. That's one way to do it. Checklists, organization is another way to focus in that way. But asking yourselves truly, when I hear an objection, well, it says the same thing, I'll pause and ask, does it really? You know, if, for example, there's an indemnity under the liquor liability clause that's specific to sale or service of alcohol, is that the same thing as we talk later on about a general indemnification that might cover negligence? Maybe yes, maybe no. So it's reasonable to ask the question. And again, working within your legal eagles, identify that up front of where a group could be flexible on this language. But, you know, pause and ask again, is it really a duplicate or an overlap of that language? Because that's going to be particularly important as the group goes through. And again, I find, Sean, even more so nowadays, there's a lot of bundling of clauses. There's a lot of things that might say the heading of the clause might be one thing, but what's in it is a whole bunch of other things. And again, sometimes that happens because these contracts come together very piecemeal. And so that being the case, being able to root through that, identify the clauses, identify the issues, that becomes particularly important. And Kelly, I know as hotels have standard forms, you mentioned standard contracts, it's important for the sales teams to understand where certain issues live, right? Where they're addressed. And I would say, whether it's the group or the hotel identifying these potentially overlapping issues or clauses, I would say it's incumbent on either side to do so and to try to root all that out before the contract gets signed.
Absolutely. Completely agree. And part of the problem when we marry, and you may have mentioned this because for some reason I got kicked off briefly, but when we do have clauses that are presented by the group or its meeting planner, and they're added as an amendment or addendum to the agreement, then it becomes challenging if you're not reconciling all of that. And if Barbara, you already said that, I apologize, but I agree that I would not leave conflicting clauses in the document. I would make sure that they are reconciled before it is signed, and that is what I encourage my hoteliers to do as well.
Appreciate that, Kelly. And we got a couple questions that came in through the chat that I think are timely and relevant to this topic. One is from Sarah. She is with a convention center, and we require groups to use our contract. And if changes need to be made, we work through edits together. We have some clients who want us to use their addendums instead of just adding that language into our contract.
Right.
And recently, a federal government event who is insisting we sign their contract. If both parties agree to the terms, does it really matter whose contract it is?
Do you want me to start?
Yeah.
Please.
So here's my concern. It doesn't matter whose form it is as long as the terminology is correct. The problem is if you're working with someone's form and it's unfamiliar to you, you are likely missing issues. And to Barbara's point, the checklist becomes very critical at that point because you may not recall when you're looking at it that, for example, we use individual pay-own, an IPO clause is missing, right? If you're using the federal government contract. Now, the federal government is a whole beast unto itself, and we don't have enough time to explore contracting with the federal government on this call. But I will tell you that they do like to use their own paper, and it is a struggle for those of us who have to review government paper because it's long and involved and includes a bunch of different statutory provisions that we have to go back and analyze to make sure it works. But for the most part, I will tell you, it really doesn't matter whose paper you use, but many brands insist you use their paper, but they will agree to an addendum. So just FYI, that may be Barbara's experience as well.
Yes, and I'll just pick up on that last point you made, Kelly, about the addendum and say that it is important as between the contract and any addendum. Remember, addendum or addenda are what we call the attachment at the time you sign the contract. After you sign the contract, you negotiate changes. That's called an amendment. It is an important distinction. And on the addendum, we want to make sure it's clear if there's any inconsistent terms between the contract and the addendum, we understand which controls. So I always make that point. The convention center side, I appreciate the question. I work a lot for groups with convention centers. And I would suggest that, again, understanding the constraints of a center, perhaps government-owned, quasi-government-owned, the need to use specific language. When you're presented with a group that has their own language, pause and ask to the group, and maybe you identify when you see their language, what issues they have. Again, I'll use construction as an example. The groups clause might speak to notice, when notice is given, what's involved, and so forth. So you could ask as the sales side, or the group could communicate to you, where do you see the gap between our language, the center language, and your language? And the group might say, well, your language doesn't even require you to give notice unless it's something that happens within 30 days of our event. Okay, if I'm the sales side, I understand, I'm hearing we could modify the clause or agree on something to where the group gets notice. So that's just one simple example of how you could use issue focused to deflect, if you will, or integrate group's language into a center contract. Similarly, I think hotels could use that same approach, but it is issue focused. I think that's a good way to do it. I think, it never helps, we never change, or we don't. I've had some, centers or hotels that, well, don't even try to change our contract. We're never going to change it. Okay. I mean, if that's true, then I would tell my client to negotiate with their feet and look for another venue. We all know, we should start out, to me, I always say, stay away from the absolutes, right? The never and always, stick to the middle lane and have the conversation. I think that's often the most effective strategy. Sean?
We're going to go to the next question, which I think is a pretty hot topic right now, especially as it relates to contracts. And Barbara, I'm going to ask you this question to start. What should we consider when using AI to review / create contract clauses? Is that a good idea, bad idea? What are your thoughts?
Yeah. So as a lawyer, I'm probably going to say something that might surprise some of you and say, I think it could be a good idea. Now, there's a lot of it depends, second time, for those of you the bingo card, wrapped up in that. But first, I would say AI is great for understanding of a particular issue. So if, for example, you say, what's an indemnification clause? Or what does it mean to be named as additional insured? That's a great awareness building. And so going back to our strategy about issue focused versus clause focused, understanding an issue, go for it. Use AI. That's great. Do not, under any circumstance, feed any confidential information into an open AI system. That's already probably breaching confidentiality obligations that you have. So that I would say first and foremost. In terms of reviewing a contract, I very much caution on that. Again, that's not to say you couldn't try it. First, is it a closed AI that you might be feeding a contract in? If not, it should be. That would be an important element because there's confidential information in there. But make sure, when you're reviewing a contract, there are lots of nuances, many of which we talk about frequently. So I often get concerned that AI might spot some issues, but not all issues. So use it perhaps if you wanted to as a first sort, as a way, again, to help organize issues. I think that could be a good tool. The other concern I have in creating a clause is that you may have, say, create the best attrition clause ever, and it writes whatever. And then that clause gets override because in the hotel contract, there's something on page 10 that says something different, right? There's some other nuance. There's a prevailing party attorney's fees clause and so forth. And so it really depends, the integration of all the clauses together. That's really where the sweet spot is, where you want, legals or others to weigh in on it. But again, it's not to say you should be scared of it or you shouldn't use it. Obviously, aside from those examples, I would just say if you're using it for drafting a review, be very careful. Do not treat it as the spoken word. Always vet it. Ask questions. And importantly, Kelly, I know from the hotel's perspective too, there are often a lot of terms that interplay with one another. And if one gets changed, the other might need to get changed.
Absolutely.
And AI might not see that on the contract.
The only thing I will add, and to Barbara's discussion is it's been my experience that, first of all, you are violating the confidentiality provisions likely in the contract if you feed anything into a public AI system. So be mindful of that, because some of the groups on this call are with very large entities that have very robust confidentiality provisions, and internally then you're violating your own provision that not only the hotels, but more importantly, I have found that a lot of the AI platforms spit out, frankly, information that is false. I mean, look at all the law firms, if you follow the news, that have been fined by various courts for creating absolutely false briefing because they relied on AI. And the same is true of clauses. Sometimes they incorporate provisions or concepts that are frankly incomplete, inaccurate, or false. So I'm not suggesting that you shouldn't use it for generating ideas. I absolutely think it's a great source for that. I just don't know how much I would rely on it for the final word and the final language.
Well said. We all know AI can hallucinate a lot, so definitely proceed with caution. All right, next question. Kelly, how has the administrative executive orders or declared federal emergencies in various cities impacted a group's potential liability for attrition or cancellation in hotel contracts?
Well, obviously, this is a very timely question. We do see lots of things that are going on in the news and in the world that cause concern. But I will tell you from a contracting perspective, the federal government's declarations and executive orders have not, in my opinion, triggered viable outs under various cancellation clauses, and that includes force majeure, because that's really what you're going to circle back to as your force majeure clause. Those executive orders, there always could be an argument depending on what the executive order is, but I would say generally the people, the forces going into DC, the announcement today that they're sending forces into Memphis, those types of things, for those of you in Memphis who hadn't heard that yet. So those types of things are not triggering a right to cancel without payment of cancellation fees. There could be an attrition situation, but remember, you've already negotiated the out of about 15 to 20%, depending on what your contract says, that allows you to adjust your room block for various things, which include those types of guests who don't want to travel because they're fearful of folks being on the streets. I will tell you from a commercial perspective, we have just not seen anything, using DC as an example. There were no road closures, or at least the road closures for the guard that were in town were certainly a lot less than any other dignitary or the president zooming around DC. There were no streets blocked because of them. And so when you get to questions like this and the impact of those decisions of the government on being out of a group contract, most of the time there is not a right. Now, I'm sure Barbara will elaborate on that further. There could be some negotiations made that give you more latitude or leeway. And of course, there's always the one-off circumstances, but generally speaking, under a standard force majeure clause, that wouldn't give you an out. Barbara?
So I agree, Kelly, that it's going to depend on the language. And you gave a lot of great examples of some of the things that groups have been managing over the last couple of months. There are groups and their clauses that may have a particular trigger, as we talk about force majeure, on the grocery list of something that does impact an executive order. And certainly that could meet a standard of impact to the group that does allow for cancellation without liability. But it's all going to depend on the clause, and it's all going to depend on the situation. My experience has been that those groups that have been impacted by executive orders, while they might have a point, an item in the contract to point to, if you will, that might speak to the potential of a cancellation or a break on attrition, if you will, those groups are often better served by quickly putting the hotel on notice. So I have a client a couple months out. They saw this coming, started putting the hotel on notice. Hey, we may not use as many rooms. We may not use as much food and beverage revenue and so forth. Talk about it early, talk about it often, and in particular, talk about what you as the group want done about it. Because if the group is going to proceed with its meeting, then it should right-size the contract. It should talk to the hotel about right-sizing the contract. Doesn't mean the parties will agree on all those terms, but it does help mitigate damages on both sides. And as the group, be prepared to give things back. Look at the concession list. Could I give back certain concessions that have hard dollar costs to the hotel in order to reduce the block or reduce the liability? To me, that's the better approach. If the group can't have it, I have had clients, because of an executive order, they literally cannot hold their event. Certainly, that's a different position on cancellation, and we make that argument. But in most instances, as you point out, Kelly, the group might proceed with the meeting, but the concern is on performance, attrition, perhaps food and beverage. So being specific, this goes back to what I mentioned earlier. This is a contingency. And if it hasn't impacted your group already, it likely will. So how do you address that contingency? It also just doesn't have to live in the force majeure clause. If you're worried about attrition and you might know an executive order 90 days out might impact your event, talk about being able to reduce your room block unilaterally 90 days out before you get attrition. If you're worried about cancellation due to government pulling funding and you think that would happen 90 days out, look at the cancellation fee schedule and negotiate a lower cancellation amount within that tier. So there's a lot of other levers that could be moved to address this contingency besides the force majeure clause, but it's a reality of what we're living in. And it definitely illustrates the point that, from hosting meetings and events, groups and hotels, we've got to be prepared for the environment that we live in. And we need to figure out how best to address those contingencies in a manner which both parties will agree they can tolerate. I speak a lot about risk tolerance and what kind of risk tolerance could you accept. And again, if your group is particularly vulnerable to acts of federal, state government, that's got to be communicated up front. Again, going back to that RFP as well. Sean, I think using the Hopskip platform as an example, I know ways to identify some of those hot button issues are built in too.
Exactly. Yeah. Always communicating it up front to save a lot of headaches and stress on the back end. On that topic of force majeure, this is a perfect time to take a pulse check from the audience. Have you ever had to enforce a cancellation clause with a client or a venue? We're going to administer a poll. It looks like it's open right now. Let's see how the results are coming in. Most folks have said yes. Yeah, not 90%, 92% have said yes, and this small percentage have said no. Thank you for everyone who's participated. We'll leave it open for a minute or two longer, and we're going to go to the next question, though, for the sake of time. All right. What are the consequences of canceling a meeting and not paying the cancellation fee, Kelly?
Well, so one of the hats I've worn throughout my career is I'm also transactional, but I'm also a litigator. And so I will tell you, I have litigated this very issue multiple times. And, I hate, depending on whether, I'm not going to opine on the reason for not paying the cancellation fee, but I will give you the process that happens if a cancellation or attrition fees are not paid. If they're not resolved amicably by the parties in discussions, which is always what I recommend from initial get-go, is to sit down and find out why things are not being paid. The process is you're going to get a demand letter. If you don't pay the demand letter, the hotel is going to likely follow whatever is in the underlying contract, which is lawsuit or arbitration. Both of those they're mutually exclusive. You either do a lawsuit or you do mediation and arbitration, depending on what the clause says. And then ultimately, if the hotel prevails in obtaining a judgment against you for the amount of those cancellation fees, You could be responsible for not only the principal amount that you owed before, the cancellation fee, for example, in this case, interest on that cancellation fee, and depending on the nature of the contract and what was signed, the attorney's fees that not only you incurred throughout that process, but the attorney's fees that the hotel incurred as well. And then once the hotel gets a final judgment, means it's final, not appealable, that kind of thing, the hotel would likely come after you, and they can do a number of things. I've garnished bank accounts. I have put liens on real property. I have gone after individual assets. If there was a boat, for example, in one case, owned by the organization, I went after the boat. So the consequences of not paying a fee are that there is the cause and effect is, in many instances, if it's not resolved amicably, a lawsuit that makes your life and the other party's life difficult, and then ultimately could render a problem for you and your assets later. Barbara, have you had a similar experience?
I have, Kelly, but I think you and I have been able to resolve things far earlier in the process.
Never get to those things, right?
Than the boat side, yes. But it shows the various steps, and there's a lot of points you made in that and your response, so I wanted to address. Again, whether a fee is due, whether the group says no fee is due, force majeure, right? The hotel says fee is due. Regardless, note that in writing. Dispute the charge as soon as you get an invoice. Dispute the charge in writing and say why. And if it's an attrition fee, pay the undisputed portion of the invoice. That's first and foremost. Seek discussion and meeting among the business teams. Make sure you have the top decision makers on those calls or in those meetings. Keep the lawyers out of it. Really, keep the lawyers out of it as long as possible. And that's because, look, you might get a demand letter from Kelly, and I'll call Kelly up and say, hey, represent the group. But by that point, the business have exhausted their line. It's always going to be cost the groups more and just up the ante there. So definitely have the business discussions. Look at what your dispute resolution provision says, if you're bound to arbitration or if it's open as to any dispute resolution, choice of law, and so forth. That's big. Kelly mentioned a really important point within the master account disputed charges section, and that is finance charges or interest on late charges. Pay attention to that language. It should not pertain, that is, interest charges should not pertain if charges are disputed. Again, all the more reason to dispute in writing. But pay attention to that clause because that definitely can be a gotcha later on. And then that prevailing party attorney's fees. That it looks on its face to be, oh, well, it applies if either party's the winner. But if you take into account most disputes are going to involve money, and likely the group might owe the hotel some amount of money, it's likely the hotel will be more so the case of a prevailing party than the group. So often I do not see those clauses work in favor of the group, but you got to talk to your legal eagle about it. So I would say, doing those things, certainly doing everything the group can to get a resolution. I'm fortunate to say that, the majority of the disputes that I've managed with groups over the years do get resolved, business resolutions. Sometimes the lawyers do get involved, but a lot of times the business folks do get it involved. But when a group avoids it, it prompts it. And I understand that, right? Because the hotel, has to respond to their owners. So that's why I'll encourage the groups, communicate early and often your position and ask for a path, right? Keep the conversation path open as long as you can. That will help keep it out of any potential of a litigation or arbitration.
And to further one point on the arbitration side, I just want everyone to understand, if you have fought for an arbitration clause that includes 3 arbitrators and you ultimately, for example, don't pay something that is due and the hotel is the prevailing party, you're also paying the hourly rate for 3 arbitrators to arbitrate that action. So be very careful about what you wish for. If you want 3 arbitrators, there's a cost with that. If you want 1 arbitrator, that is a better business decision in many cases. But I throw that out there just because many of you are probably unaware of that particular hidden cost in an arbitration demand.
Great point. Kelly, construction seems to be underway everywhere. What recommendations do you have for construction/renovation clauses in hotel and venue contracts?
So hotels have standard construction clauses, and they will be more than happy to share them with you. Most of them will be happy to share kind of common language, and that may be a starting place for you if you haven't negotiated one before. But one thing I will tell you is this: hotels cannot control what the city does in front of the hotel. Hotels cannot control what a neighbor does. I even had one construction clause many years ago that allowed the group, we of course didn't agree to this, but allowed the group to get rid of the contract without penalty if there was construction between the airport and the hotel. Really? I mean, come on, where is there not construction between the airport and a hotel these days? But the reality is they're willing to do that. Most of the hotel clients, and this is just for your edification, most of the sales team is not aware of when construction is going to actually start, even if there's a discussion about construction. So you may complain that you did not get notice of some construction. Well, that's just because materials are very hard to get. Contractors aren't starting until the materials are all there. And sometimes that can turn on a dime. We don't have a lot of advance notice for construction. We can tell you if something's being contemplated, but we don't know when the start date is actually going to be. The other thing I will say on construction clauses is hotels are not going to, because of those same factors, are not going to stop construction during your event. We're going to have to make other concessions for you. We're going to have to adjust something else, but stopping construction once you get started is next to impossible for the various reasons that you can imagine, including not limited to costs, third-party vendors, contractors on the property, that type of thing. But those are my 2 cents on construction. I would say that if you want to, it's in your RFP, you want to know up front if anything's being discussed, and then you want notice. As Barbara alluded to much earlier on in the discussion, as soon as we have notice, we can give you notice, but just be mindful of the fact we're not going to know always 60 days out or 90 days out. That's just not possible. Barbara?
Yeah, and I agree with everything Kelly said with regard to construction. Certainly, to the extent that construction is a concern in or around the hotel, and the example you gave with the airport, that wasn't my clause, by the way. I wouldn't have to talk to your destination management organization, the DMO, or some of you know these as Convention Visitors Bureau. That becomes an issue as to why you might or might not select a city if that's a hot button issue for the group. I agree with the RFP. I agree with the notice. It's a business call at the end of the day, whether a group agrees to work with hotel and come up with a resolution versus having the right to cancel. Again, it's all in that negotiation, but think about all those elements. Group is going to need as much information as it can get in order to make a decision. And that's really what the groups are protecting. Remember, their meetings, a group meeting is an asset, and we want to do everything we can to protect that asset. And I know hotels understand that part, but then it's what's within the hotel's control. Again, all the examples that Kelly gave to Sean.
All right, this is going to be our last question. We're going to see if our great presenters can answer this in under 90 seconds. What is the difference between an impossibility clause and force majeure? Kelly, do you want to start with that?
Generally speaking, there is no difference. In my opinion, those are titles. The guts of those two types of clauses, in my experience, is they are all force majeure type clauses. Now, someone may use the impossibility clause to frame it as something else, but if the language is something where you're describing a force majeure, i.e. something happens that makes it illegal or impossible or whatever other term you use to hold a meeting, then they were one and the same. Barbara?
100% agree. The only thing I would add is just remember the two parts of the clause: the grocery list part, all the bad things that can happen, and the standard of impact, whether it's impossible, illegal, commercially impracticable, affect a certain percentage. Those are the two main components of the clause, no matter what you call it on top.
Well said. Well done. That is today's webinar. We appreciate everybody who signed up, who's engaged. We'll get the webinar recording sent out next week. We also have a lot of resources on our website that have been made through Barbara and Kelly's knowledge over the years. So please feel free to check out the resources section of myhopskip.com. And we look forward to seeing you on the next one. We'll be having another one of these. I believe we're scheduled for December. So we'll get that invite sent out in the upcoming weeks. And I hope everybody has a wonderful weekend. Thank you.
Thank you all.
Guys.